The next matter to come before the court this morning is State of Ohio versus Courtney Freudeman. State against waived oral argument. Counsel, you have 15 minutes to present argument this morning. We've read the briefs. We're ready to proceed when you are.
Good morning, Your Honors. May it please the Court, William Vasili on behalf of the appellant, Courtney Freudeman. What we have here is an appeal of a motion to suppress denial from the trial court level. The issue, as the Court is well aware of, having read the brief, pertains to whether or not there was sufficient reasonable suspicion based on specific and articulable facts to conduct an investigatory stop in this case. I will first note for the record that the trial court in its decision made an error in making a finding of fact. In particular, they found that the officer in question made a pass through a local McDonald's parking lot, then proceeded across the street, parked in a subway parking lot, and observed the vehicle in question park her vehicle, which is how that officer could conclude that that individual or the vehicle that is in question did not purchase any food items lawfully from the McDonald's. Now, obviously, when you review the transcript, as I've laid out in my brief, that is factually incorrect. What occurred here is the officer, who was new to this area and was only there, I believe, to cover a shift for another officer, had some previous interaction on a very basic level with this parking lot, knew it somewhat, decided to proceed there to post up because he had no active calls. As he was approaching and entering the parking lot of the McDonald's, he testified that he saw the vehicle in question backing into a parking space. So without equivocation, that officer cannot conclude whether or not that vehicle in question lawfully purchased food or didn't purchase food. What we do know from his testimony is that the McDonald's was open at that time and that that vehicle could have easily purchased food and then parked. And the reason why that is so significant is because the officer in this case was concluding that there would be no reasonable lawful manner no reasonable lawful explanation for the vehicle in question to be parked in that parking lot, which is obviously incorrect as laid out in the brief.
Well, he didn't really say that there would be no reason for the vehicle to be parked in the parking lot. I understood from the briefs that he testified as to having been a part of this drug team.
Correct.
And that based on his experience, a lot of individuals would drive to that parking lot and would park in a far corner in order to do drugs. So even if we assume that the individuals came in and went into the establishment, and I don't know what the record is going to show about how many cars were in the parking lot, but the officer seems to suggest that they went off into a far corner and parked under a light. Does that diminish the evidence for reasonable suspicion to stop?
I don't think so, and here's why. The officer was referencing in his testimony a former grant that was given for a parking lot interdiction team. That grant, from my understanding and reading the transcript, was no longer in existence. So it was based off past police intervention. And if that intervention were to be successful, I believe any suspicion of that being a crime area would have to be gone. The fact that the parking lot itself would no longer be under investigation under that interdiction team or under that interdiction grant, I think would be an assumption we could make that that parking lot should no longer be relied on as being a criminal activity area. The officer, I will honestly and directly state that that conversation never took place during his testimony, but I think it would be a fair and accurate inference we could make. Further, I think when there is an equally plausible lawful explanation, according to State v. And I'm going to botch the name, but Jacopazzi from 1983, that this court should, and the trial court should have resolved that conflict in whether or not there was a lawful reason for being there in favor of the defendant, because it's equally as plausible that she could have been there as a consumer as it is that she was there using drugs based on his assumptions. And where I think that analysis comes in is that it's a hunch and an unparticularized one. The fact that maybe there was previously some investigation done on this parking lot is something that generally applies. And I think in State v. Fox, as said in my brief, specifically says, just because we know an area, if you don't make the assumption that this is not a high crime area, and in fact you assume that it is a high crime area, that alone is not enough. And
Didn't he, I understood that the officer, after observing the vehicle, parked, as you said, in the subway across the street and ran the license plates. And so you have that as an intervening act. Presumably, that's not a violation of any rights, correct?
no,
Okay, so when he does that, he gets information that the vehicle's registered to person A, however, person who's a female, however, person B was driving it recently and did not have a driver's license, correct? So why, even if we assume, don't have any information about drugs and so on and so forth, doesn't that give him reasonable suspicion to further investigate?
well, what I would say to that, Your Honor, is the officer specifically stated he could not identify anybody in the vehicle. And what he did is he ran the registration, confirmed that Miss Ingram, who the vehicle was registered to, had a valid license, had valid registration, and that she had a valid license, valid registration, and that there were no warrants out for her arrest.
Correct.
Being that he could not physically identify in that car, he could not determine one way or the other who was in the vehicle. Now, the officer, I think at that point, could have conducted a consensual encounter, which he could have driven through the parking lot, approached the vehicle without conducting an investigative stop. That's not what happened here. He ran the license plate, researched the database, then went into, and forgive me, but some notations that are specific to the Akron Police Departments, which were not provided to the defense counsel in this case, and through his testimony, based on those notes, claims that there was some information that Ms. Freudeman had driven that car before. That information was never provided to Ms. Freudeman, nor to her defense lawyer, but that's according to the testimony of the officer. In fact, he waited for that vehicle to exit the parking lot and then conduct an investigative stop. I would not have had an issue had the officer conducted a consensual encounter, approached the vehicle, knocked on the window and said, what's going on here? But I don't think, based on the current situation that he was in, having just maybe seen a car back in a parking lot, not being able to identify who was in that car, and running a leads report on it, or checking the fact that it was owned by a lawful person and maybe somebody else could be driving it, in and of itself is particularized enough to indicate that criminal activity is afoot. I mean, there's nothing to suggest that a crime is occurring at that point.
Did he testify that at the time that he stopped the vehicle, that he could or could not tell that the driver was a female?
At the time he stopped the vehicle?
Correct.
I believe the testimony in the transcript is that when he stopped the vehicle, he approached it, and I don't think he had a physical description of Miss Ingram or Miss Freudeman, but I think he took the license and that's when he determined as Miss Freudeman. Whether or not he could identify who was in the vehicle, I don't think that was until he approached the window. So the significance here, Your Honors, is obviously this is the totality of the circumstances. We have a trial court that relied on a fact that was not in evidence, which I believe when you switch out the correct fact with the incorrect fact, the analysis in this case changes, mainly because there is a perfectly lawful reason for that car to be in the parking lot. The officer's unable to identify anybody else in that parking lot. He's relying on old information as far as this being a crime area, and he can't even identify the persons in the vehicle. Therefore, when he says there's movements in the car, I don't think that has any weight. I would cite back to State v. Fox again, stating that movements in a vehicle in and of themselves are not reasonable suspicion. And that's in paragraph 18 and 19 of that case. And to that end, Your Honor, I think that this court, I would ask on behalf of Ms. Freudeman, issue an opinion reversing the trial court's decision and remanding this matter with specific instruction for the court to suppress the evidence that was ultimately found in Ms. Freudeman's motor vehicle that she was driving that evening. Thank you.
Thank you, counsel, for your presentation this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website, which can be linked to through the National District Court of Appeals website. Thank you.
Thank you, Your Honor.